a certain period of time, and the court scheduled a hearing about the issue on September 28, 2023 before Judge Stephanie Boyd in the 187th District Court in Bexar County.
All right, court is calling 2022 CR 10. Oh, she doesn't have to be unless she wants to sit. Court is calling 2022 CR 10642, State of Texas versus Jose Sanchez. Could I have parties announced for the record for the state?
Hank Wilkins for the state.
Defense?
Eric Baker for Mr. Sanchez, Your Honor.
And are you Mr. Sanchez?
Yes, ma'am.
All right. The reason we are here is the defense alleges and your client alleges that there was a video in a holding cell of your client, and it is potentially Brady.
Yes, Your Honor.
With regards to this case. Is that correct?
That's correct, Your Honor. Yes.
All right. State, are you prepared to proceed?
We are, Your Honor.
Defense, are you prepared?
Yes, Your Honor.
All right. State, do you have any witnesses?
Well, it's really, I guess more of a defense witness.
Because I wouldn't mind taking the lead if the state's okay and report the case.
All right. Who would you call?
Who would call
Deputy Chief.
Deputy Chief Pruitt of the Alamo Heights Police Department.
All right. Deputy Chief, if you could raise your right hand for me. Do you solemnly swear or affirm the testimony you give will be the truth and nothing but the truth, so help you God?
I do.
All right, you can lower your hand. Just make sure you keep your voice up for the court reporter. If you could state your name for the record, please.
Cindy Pruitt.
All right. Defense?
Thank you, Your Honor. Deputy Chief Pruitt, thank you for coming in today. So, Deputy Chief, the video that the court was talking about, you're aware of what video that we're talking about, correct? That we're looking for?
That's correct.
Okay. Now, before we get into that, I just want to ask you, when we initially asked for this video, we got word back from your department that there are no videos taken in that area of the department. Were you the one that conveyed that information to Mr. Wilkins?
No, I'm not sure what you mean there are no videos taken.
The first request to your office from Mr. Wilkins requested the video that we're talking about today. And my understanding is that your understanding that your office replied back that there was no videotape in existence. In fact, there was no videotape equipment to videotape at all. Is that your response in the office?
No, that wasn't my response. And in fact, I didn't respond to that. I'm not sure. Do you have the response you're questioning about?
The state has your email, but I'll move on. I wanted to know if you were aware of that.
All right, and counsel, so that the record can be clear, when you speak of video, what video are you talking about?
The video of Mr. Sanchez upon his arrest when he was in the holding cell or near the holding cell in Alamo Heights Police Department. You aware of that video?
I'm aware that that video doesn't exist because it was purged from the system.
Keep a sharp watch here.
And one of the main question, this is your first time here, maybe your first time hearing them, is the court had a question, and I think I did too, as to when that video was destroyed. Do you have personal knowledge as to what day it was destroyed?
No, we attempted to recover the video, but we don't have any way to determine when it was destroyed because it's a surveillance system that is on a loop. And as new video comes in, because it runs 24 hours a day, it's a very small server, the older video purges off and it just is replaced by the new videos.
You can't testify today as to when that video was purged, correct?
No, sir, I cannot. I can testify to the fact
That's
that...
just a yes or no question.
No, sir.
Ma'am, I just talked to you in the back, correct?
Yes.
And we talked about, I asked you, is there anybody who can make that determination or tell the court? We spoke about someone named Marcus, correct?
That is correct.
And when I asked you, you sent an email to Mr. Wilkins yesterday, or 2 days ago, I'm sorry. No, yesterday, on Wednesday, that he would not be...
Counsel, if you could slow down.
Certainly. That he would not be in attendance today. Is that correct?
That is correct.
And when I asked you why back in the back, you said somebody made a decision that if he wasn't under subpoena, they weren't going to send him. Is that correct?
His leadership for his company made that decision, yes.
So he's really the witness you need to talk to bring that yourself, correct?
His supervisor is available today by phone.
Can you come in?
I just found this out right before I came in here. They said they would make him available by phone.
Does he have knowledge of what we're looking for in the background so that we don't have to start over with him?
Yes, he has knowledge, yes.
Okay. When could he come in physically?
Oh, that I don't know. I didn't ask him.
Is he available to appear by Zoom?
I believe he's with an IT company that is our vendor.
All right, counsel, would you have any objections to him appearing by Zoom?
I would not, Judge. I just want to make sure that, I know that Marcos has information. I'm just curious as to why we can't produce Marcos. His supervisor is going to be a level up, and Marcos has hands-on
Well, is Marcos available to appear by Zoom, or does he want to
When I
subpoena?
spoke with his supervisor just a moment ago, Your Honor, he was directly involved with the process with Marcos, and he is a higher level IT technician than Marcos even is.
All right, so the defense wants Marcos here. Is that correct?
I think Marcos and his supervisor, Judge, just based on the history of this case, Your Honor. I mean,
All right, so I like to cut through the chase. Is Marcos and his supervisor available today by Zoom?
I would have to ask, Your Honor. I asked if they could be available by phone, and he gave me his phone number and said that he was. I didn't ask about Zoom.
All right, does anyone mind us taking a short break so she can see if they're available by Zoom?
not at all.
Thank you so much.
Your Honor, they do have an answer to give to the court.
Okay. So are they going to have the person here or no? We really need a subpoena.
I guess, Judge. I think that you have other remedies, but yeah, I mean,
We're back on the record in 2022 CR 10642, State of Texas versus Jose Sanchez. Deputy Chief, what are the results of your inquiry?
Their HR department is denying them showing up on Zoom. They said that because they were asked to do a task, they completed the task and they recorded all of the information on the ticket, which was then emailed, but that's the only involvement that they have.
All right, well, if you would let them know, they can appear by Zoom or they can be subpoenaed, which means,
Should advise them of that, Your Honor.
all right.
Judge Boyd asks Deputy Chief Pruitt to contact the police department's IT consultant, Barcom, to determine whether the employees who worked on the case are available to testify via Zoom. And when they decline to appear virtually, Judge Boyd advises that they can be subpoenaed. In general, a witness does not have to appear in court simply because the judge or a party makes an informal request, including a request to join by Zoom. The mechanism that makes a witness's appearance mandatory is a subpoena, and under Article 24.01 of the Texas Code of Criminal Procedure, a subpoena is the formal process used to summon a person to appear and testify in a criminal case, either on a specific date or for a specified period of time. Once a subpoena is properly issued and served, the witness's obligation changes from voluntary cooperation to a legal duty to appear. And under Article 24.05 of the Texas Code of Criminal Procedure, a subpoenaed witness who fails to attend may be fined at the discretion of the court up to $500 in a felony case or up to $100 in a misdemeanor case. Additionally, Article 24.11 of the Texas Code of Criminal Procedure authorizes a court to issue a so-called attachment directing law enforcement to take the witness into custody and bring the witness before the court to ensure they appear. Accordingly, while the Barcom witnesses were lawfully permitted to decline the informal request to testify by Zoom, if they are subpoenaed, they will be required to appear in court or face legal consequences.
Before we get into this video, I want to thank the sponsor of today's episode, Incogni. Quick question. Have you ever searched your name online and found your address, phone number, or relatives on random websites? That is not just creepy. It is the kind of information scammers use for identity theft, fake credit applications, SIM swaps, and targeted fraud. Incogni helps remove your personal information from the internet, not just from data brokers, but from hundreds of people's search and other eligible websites. You create an account, provide minimal information, authorize Incogni to act for you, and they handle the removals. They send requests automatically, follow up repeatedly, and keep monitoring so your data does not quietly reappear. You also get monthly updates and 24/7 support. If you choose unlimited or family unlimited, you get custom removals. If a
Ooh, this
specific
should be
site is
good.
exposing your info, send the link and a dedicated
On December 10th, 2025, officers Abdullah Mohaizen and Christopher Reyna of the Romulus Police Department stopped a vehicle driven by defendant Cassandra Irick in Romulus, Michigan, after observing that the vehicle's rear window was obstructed. During the stop, the officers learned that Ms. Irick's driver's license was suspended, and she was placed under arrest. A search of the vehicle produced suspected controlled substances, and Ms. Irick was charged with one felony count of possession of a controlled substance analog. Ms. Irick was arraigned on June 9th, 2026, and released on a $5,000 personal bond. And on June 30th, 2026, the matter came before Judge Brian Oakley in the 34th District Court in Romulus for a preliminary examination, where Ms. Irick was represented by defense attorney Martha Ridgway. The prosecution called Officer Mohaizen as its first witness, and following his testimony, called Officer Reyna to the stand.
Good morning. Raise your right hand. Swear affirm, tell the truth, the whole truth, nothing but the truth today.
Watch your step on my ramp. Have a seat. When you're ready, Carl.
State your name.
Officer Chris Rain. Ground
Officer Rain, good to see you. Officer Rain, how many years have you worked for the Rhineland Police Department?
10 years in July.
Taking you back to December 19 of last year, 2025. About 4 in the afternoon, were you working?
I was.
What were you doing with it?
I was on patrol.
Did you have a partner or were you acting alone?
Had a partner, Officer Myson.
Are you in a marked vehicle or unmarked?
Mark.
Uniform or no uniform?
Full hat vehicle.
Did you have contact with a woman named Cassandra Eric?
I did. Yes.
Where did you have contact with Cassandra Eric?
In Ron, City of Romulus.
In what municipalities are local? You said Romulus.
Correct.
Officer, what caused you to notice this person, Cassandra Eric?
The rear window of her vehicle was completely blocked, as if she wouldn't have been able to see out of it.
Is that a ticketable offense?
As far as I understand.
Do you remember where precisely you first encountered the driver of the vehicle?
It was in the area of Eastern, as I recall.
As a result, I was saying, start the window, the windshield, windows, what did that do?
I conducted a traffic stop.
Do you remember what type of vehicle this person was in?
I remember it being a smaller sedan. I don't remember the specific make and model.
Do you know whether the driver was alone in the vehicle? If you saw the driver in that vehicle, then you could recognize him?
I would.
What's more important, what Judge Hogan know whether you see this?
The young lady.
Your Honor, may the record reflect the witnesses identified.
No.
We made a traffic stop or initiated a traffic stop.
Correct.
Driver with the siren.
She did. I made contact with the driver's side of the vehicle, and we discovered that her license was suspended.
What did you do when you learned the other lady's license had been suspended?
So with our policy and procedure, it's an arrestable offense. I got her out of the vehicle, placed her in handcuffs, and walked her to the patrol. After conducting this on her person.
Did you conduct a search on the person?
I'll be honest, the person, I don't remember if it was myself or my partner, Officer Mahyson. I know I searched the vehicle, but I can't recall at that moment if I searched her person. Either one of us would have conducted a search.
I'm sorry, any contraband found?
Not on her person.
Did you find any kind?
I did.
What contraband?
It was inside of a purse, which had a couple plastic baggies in it. It was on the passenger side of the vehicle.
Officer Reyna explains that after Ms. Heatlh was arrested, either he or Officer Mahyson searched her person, and that he searched her vehicle and found suspected controlled substances inside a purse on the passenger side. Under the search incident to arrest doctrine, as the Supreme Court held in the 1973 case of United States v. Robinson, a lawful custodial arrest justifies a full search of the arrestee's person without any additional showing of probable cause or suspicion. So, the search of Ms. Heytlh's person required nothing beyond the validity of the arrest itself. However, the search incident to arrest doctrine reaches a vehicle only in narrow circumstances. In the 2009 case of Arizona v. Gant, the Supreme Court held that police may search a vehicle following a recent occupant's arrest only when the arrestee is unsecured and within reaching distance of the passenger compartment at the time of the search, or when
Greece is so beautiful.
that the vehicle contains evidence of the offense of arrest. Neither circumstance was present here, as Ms. Heatlh was handcuffed and secured in the patrol vehicle before the search, and an arrest for driving on a suspended license offers no reason to believe that evidence of that offense would be found in the vehicle, much less inside a purse. Although Officer Reyna did not identify the legal basis for the vehicle search, the most likely justification is an inventory search, as a vehicle is ordinarily towed when its driver is arrested and no licensed driver remains to take custody of it. Well, in the 1976 case of South Dakota v. Opperman, the Supreme Court held that when police lawfully impound a vehicle, they may inventory its contents without a warrant, as long as the search is conducted pursuant to standardized procedures. Here, because Ms. Heatlh was arrested and no other licensed driver was present to take the vehicle, an inventory conducted in preparation for towing would have permitted the officers to examine the vehicle's contents, including the purse on the passenger side, provided that the underlying arrest was lawful.
Any other women in the car or standing in the car?
No.
Officer, what happens when you confiscate what might be controlled substances?
We collect it, we hold it with us until we take it to the station. We kind of do what we call processing the evidence. So we secure it in generally a manila envelope or a plastic bag. We secure it with property tape. Put it in a drop box with what's called an MSP lab sheet, which is just us asking the Michigan State Police to do an analysis of what we believe is narcotics. And then
The family was stating that she had a valid prescription for the controlled substance.
not that I recall.
So what happens ultimately to this defendant?
She'll be arrested for possession of narcotics.
Hey, there, another thing.
Cross, Ms. Ridgway.
Officer Rena, you were driving, right?
Yes, ma'am.
So you're the one who pulled over your scout car.
That's correct.
And you did that because of the alleged obstructed rear window of this Ford Focus.
Correct.
You didn't really notice anything else about this car, right? It had a mirror. It was find her.
Ms. Ridgway conducts a brief cross-examination, confirming that the only reason for the stop was the obstructed rear window. Officer Reyna agreed that he did not notice anything else that was wrong with the vehicle, that it was operating fine, and that, as far as he knew, it had all of its mirrors. And with that, Ms. Ridgway concluded her questioning. Officer Reyna was excused, and the state rested its case.
I should return to Maya.
People are
Any defense witnesses? Ready for argument.
having case thousands of times across the United States.
You led me on a good shake.
You have police officers on patrol and not vehicle checks. They observe a car with obstructed view. They learn that they suspended license. They do no judge. That's an arrestable offense. They arrested her. They search her. Instant arrest. And it's unclear as to who did what. Collectively, the two of them confiscated the drugs, and you know that they followed procedure in both of them. That's what happened. We would see the final charge.
Counsel.
I should find Calipatira's son.
This case
He should
was
be
a
able to help
violation
me
of
with this
Ms.
matter of
Iris
citizenship.
Workman rights, and she's pulled over for this alleged infraction. MCL 257.709 clearly states that a person shall not drive a motor vehicle if driver visibility through the rear window is obstructed unless the vehicle is equipped with two mirrors, one on each side. So the only way that they could have probable cause to pull over Ms. Iris on this day is if her was obstructed and she was missing one of her two side mirrors. We just heard Officer Rand say nothing else was wrong with the vehicle. There was no probable cause to stop the car. That is from Wren versus the United States. That is established law. There was no probable cause to believe a traffic violation.
Ooh, sexy.
Ms. Ridgway argues that the officers lacked probable cause for the initial traffic stop, and that the arrest and search that followed were therefore unconstitutional. Under Section 257.709 of the Michigan Penal Code, it is unlawful to drive a motor vehicle if driver visibility through the rear window is obstructed, unless the vehicle is equipped with two rear view mirrors, one on each side, adjusted so that the operator has a clear view of the highway behind the vehicle. By the statute's plain terms, an obstructed rear window is not a violation when the vehicle has both side mirrors. And Officer Reyna testified that Ms. Irick's vehicle had its mirrors and that nothing else was wrong with it. Now, generally, if a traffic stop is unlawful, so is the evidence it produces. In the 1963
Yes.
case of Wong Son v. United States, the Supreme Court
Let's
held
get him.
that evidence obtained
Oh,
by
he's right there.
fighting unlawful police
Very good.
conduct must be excluded as so-called fruit of the poisonous tree, meaning that an unlawful stop would render the arrest invalid and the suspected controlled substance inadmissible, leaving the state with no evidence to support the charge. However, although a stop made without probable cause of an actual traffic violation is ordinarily unlawful, in the 2014 case of Hine v. North Carolina, the Supreme Court held that the suspicion required to justify a traffic stop can rest on an officer's reasonable mistake of law, meaning that a stop remains constitutional where the conduct of the officer observed was not actually illegal, so long as the officer's belief that it was illegal was objectively reasonable. In the Hine case, the officer stopped a vehicle with one broken brake light under a North Carolina statute requiring vehicles to be equipped with a working stop lamp. At the time of the stop, no state court had interpreted the meaning of the statute, and so it could reasonably be construed to require two working lamps when read in combination with other parts of the statute. Although the statute was eventually interpreted as only requiring one brake light, the court concluded that an objectively reasonable officer could have believed that a faulty right brake light was a violation of the ambiguously worded statute, and therefore that the traffic stop was supported by reasonable suspicion, making it lawful. Now, the statute in question in Ms. Irick's case leaves no comparable room for doubt, as it expressly conditions the violation on the absence of the two side mirrors, and a court would likely conclude that a mistake about the explicit terms of the statute that an officer is enforcing is not the kind of reasonable misreading that renders a stop lawful under the precedent established in Hine.
Mr. Kaplan, argument.
We heard unequivocal testimony that that vehicle is still the Ford Focus 2012 and an obstructed rear window. That's dangerous. It's dangerous driving that way. It could lead to accidents. Legislation doesn't want that. In this case, that's what she has. The question is that the jury,
Essentially, the police have to follow the law. They both testified as police officers that they know the law. They pulled Miss Heatlh over outside of their bounds as law enforcement. Okay, I understand seeing something obstructed, thinking, oh, maybe she can't see, but unless you have probable cause for facility open for a traffic infraction, you cannot do that. And from this infraction, Miss Heatlh was arrested, a search was conducted. That is all through the police history in this case. Thank you.
How is it probable cause if it's not a infraction? She just read me the statute, and it said that the obstructed window is only an infraction if she doesn't have side mirrors. I did. She asked him if he noticed anything else about the car. Did it have its mirrors? And he said, as far as I know.
The position that had he not stopped there to get involved, could have been a very serious accident.
Could have been. But I drive an F-150 with a cap on the back, and I can't see spit out my window other than headlights at night. Dismiss.
Good police work doesn't always end up with convictions.
Well, you don't get many of those like you just had. That just straight up. Yeah, but I mean, you just don't get too many of those. Just that straight up bad. I mean, they thought they had a good reason.
No, they think she did the research on him.
No, as soon as he started saying the reason for the stop, I'm like, wait a minute, I can't see out my back window unless there's headlights behind me.
Following the parties' arguments, Judge Oakley dismissed the charge against Ms. Heatlh, and the case was closed later that same day. This hearing demonstrates that an officer's authority to stop, arrest, and search a citizen depends on the officer knowing the law well enough to recognize when it has actually been broken. Officer Reyna saw a blocked rear window and he treated it as a violation, but the statute that he relied on says that an obstructed rear window is only a violation when the vehicle lacks its two side mirrors, and Ms. Heytl's vehicle had both. The fruit of the poisonous tree doctrine enforces that principle by excluding evidence that the government would never have obtained without the unlawful conduct that led to it. In this case, the stop produced the arrest produced the search, and the search produced the suspected controlled substances. So, when the stop was found to be unlawful, none of the evidence obtained from it could be used against Ms. Heatlh in court. The exclusion of evidence carries real costs, and there is no question that it sometimes ends prosecutions that might otherwise have succeeded. But it is also what gives officers a reason to learn the statutes before enforcing them. Since a department that treats the details of the vehicle code as an afterthought, they're going to watch their cases get dismissed one unlawful stop at a time. Ms. Heytl's case ended because a single sentence of the Michigan Vehicle Code did not say what the officers believed it said. And when an officer's understanding of a statute is enough to justify handcuffing, searching, and charging a citizen, that interpretation must be correct, or at minimum, reasonable before the law will permit the resulting evidence to be used against that citizen in the courtroom. On July 11th, 2025, 39-year-old Eric Littleton was arraigned in the 34th District Court in Romulus, Michigan on 3 felony charges of first-degree criminal conduct causing personal injury, third-degree criminal conduct through force or coercion, and larceny in a building. A so-called preliminary examination was set for July 30th, 2025 in the courtroom of Judge Brian Oakley. As we discussed in a previous episode of ATC, a preliminary examination is a hearing held in a Michigan district court after arraignment in felony cases in order to determine whether there is probable cause to believe that the defendant committed a crime. If the judge finds probable cause, the case is bound over to circuit court for trial. Court records show Mr. Littleton's attorney of record as James Earl King Jr., a supervising attorney for the Neighborhood Defender Service, an indigent defense organization in Detroit. However, on July 30th, 2025, staff attorney Sahar Faraj appeared on his behalf to represent Mr. Littleton for the preliminary examination in the courtroom of Judge Brian Oakley.
Appearances for versus Littleton.
Oh, okay, I just gotta talk to him.
James case, and I have a lot of
All right, ladies, we ready to go?
Yes, Judge. They would have created out of this country to be here today.
All right, put on the stand.
Mr. Wilson was in the opportunity at this time, the defense counsel is adamant that Mr. Wilson is no way understanding the nature or the outcome, so they can get out. And that's. But for his head, he did not fully aware of try to outstay,
Let me stop you. When did you talk to him of realize you had this problem?
well, it's been in compounded conversation, so this person, the honor was, judge.
Was not.
The statement saying that I didn't think any.
Counsel, my question was a simple one. When did you know you had this problem?
Somehow it's a compounded issue, Your Honor. It wasn't just the first time, it was the second time also.
Denied. Denied. Twice I've asked you a direct question, you can't answer it. No, I asked you for a date. When did you know you had the problem? They flew somebody in from out of the country. If this was a problem you could have told them about a week ago, we could have avoided that. So we'll go ahead with the exam. You can do whatever you want. You can build whatever your record is. We're going to use the witnesses that are here today. I didn't ask for an argument, counsel. I just told you my decision.
Going to be completely, I couldn't to be ready and what can be administered. Mr. Wilson had no opportunity to review the discovery. I'm not the attorney of record.
Then why are you here? Who's the attorney of record?
And that is correct, Judge, as much as Ms.
So schedule a show cause for Attorney King for contempt of court. Would someone like to explain to me why the attorney of record is not here for a scheduled exam?
I'm here anyway, because Wilson wanted to refer to
No, he wasn't. No, he wasn't. You were going to ask for that.
the court was definitely required that the court at least consider that the referral to competency at this point in time juncture. I understand that there has been a delay in the complaints from out of the country. However, the statute is very clear. And if Mr. Littleton did not assist rationally, let alone present what is actually happening, the court has an obligation to consider.
Ms. Farage informs Judge Oakley that she is concerned about Mr. Littleton's competence to stand trial. Courts have long held that subjecting a mentally incompetent defendant to criminal prosecution is unconstitutional. In the 1960 case of Dusky versus United States, the Supreme Court established the controlling standard for competency. A defendant must have sufficient present ability to consult with his lawyer with a reasonable degree of rational understanding and to understand the proceedings against him. Building on this holding, the court concluded in the 1966 case of Pate versus Robinson that failing to provide a competency hearing when evidence of incompetence exists violates due process. Michigan law directly incorporates this constitutional principle. When the issue of competency is raised in a pending proceeding, Section 330.2026 of the Michigan compiled laws requires the court to order a mental health examination of the defendant. Under Section 330.2028 of the compiled laws, the evaluator must submit a report to the court that addresses whether the defendant is competent, and, if they are not, whether there is a substantial probability that competency can be restored. The court will then hold a hearing to determine competency after the report is submitted. Here, because the issue of competency was reasonably raised, the court could proceed with the preliminary examination until it had been determined whether the defendant was competent to stand trial. This means that testimony could not be taken from the witness who flew in from out of the country.
Here's what I consider. Your office is continuing to do this to the court docket with attorneys that are scheduled that don't show, don't call, just don't. We've got attorneys that show up the day of the exam having never spoken to their defendant repeatedly, day in, day out. Every Wednesday we have the same thing. Your office is disrespecting the Wayne County bench. Is that clear? We've been told we have to actually hold you people in contempt so that they can withhold the payment for the job that you're not
This
doing.
must be the antidote.
Would you like to say anything?
Judge, I just asked for an opportunity to make a fair record, if I may.
Go ahead.
So first of all, I would like to note that this is my first time actually working with Miss Barrage. This is not, I believe, her choice. I believe she was sent here by Mr. King.
Oh, it sounds like they threw her to the wolves.
I just want to acknowledge that. Don't think that this is a problem for me.
No, she's just lucky enough to be the one I yell at. Yeah.
Heatlh.
I contacted Mr. King. I called NDS, contacted them specifically so that I could figure out ahead of the PCC the defense attorney was. I found out that it was Mr. King. I contacted Mr. King. I got a hold of him that day. It was the day before the cause conference. I let him know that I was personally sending him the visual discoveries so that he could do it. I indicated that there may be some competency concerns, and I asked if he would let me know if he would be referring to competency. I also let him know that I spoke to the out of the country complaining that is confirmed the next 4 to 6 Wednesdays free on her schedule, and let her know that he's fine for me. And told Mr. King that I would make any of those days work, but that if we schedule an exam for her to be flown into the country, the judge is very important is happening at the airport. So flown into the airport that she was sexually assaulted in, then if that happened, and if she came here, we were holding this exam. Because I was not going to have this exam all the way back. Only to be told that there was an adjournment request or had to be reported to practice. I asked Mr. King that. I did feel at the time like he was dismissing me, but I also recognized him for the PCC. The PCC happens. I clearly I was not present when the actual date was set. It was set for 7 days out. We did everything that we could to get the victim here. I had the officer in charge of meet her where her plane landed after the actual date, to get her from the gate through the airport. Again, she was sexually assaulted to her hotel to keep her calm because she's been extremely traumatized as a result of this. Prior to this, after all the arrangements were made, I started calling Mr. King 48 hours before the victim needed to leave the country, just to confirm that he was not planning on actually adjourning for discovery, to confirm that he was not planning on referring to the defendant for competency. He refused to call me back, refused to answer my text. I got a call from him this morning at 8:30. It was the first time he has spoken to me since pre-PCC last week. And that is when he told me that he had not spoken to his client, that other members of his team had fortunately stepped in to speak to his client for him when they were concerned about his competency and that he wasn't sure if the defendant would be able to sit through this hearing.
This is totally unconscionable.
The prosecutor explains that she attempted to reach Mr. King to determine if he had intended to raise the issue of competency before she had the witness fly in from out of the country for the preliminary exam, and he did not return her calls. She also states that she finally got in touch with Mr. King that morning, and that he informed her that he had not spoken to the client. Mr. King's failure to meet with his client and attend the preliminary hearing raises several ethical issues. For instance, according to Rule 1.1 of the Michigan Rules of Professional Conduct, lawyers must provide competent representation to their clients. In part, this means that attorneys cannot handle legal matters without adequate preparation and cannot neglect legal matters entrusted to them. Likewise, Rule 1.3 requires lawyers to act with reasonable diligence and promptness in representing their clients. And Rule 1.4 requires attorneys to explain matters to their client to the extent reasonably necessary to allow the client to make informed decisions. Accordingly, Mr. King's lack of communication with his client and his absence from the preliminary hearing could be perceived as potential violations of his professional duties of competence, diligence, and communication.
Mr. King better bring a toothbrush when he comes for the show cause. Please send that message. Clear? Counsel? Clear? Answer my question. Clear? Make sure he brings a toothbrush when he comes for the show cause. Thank you.
Judge Oakley tells Ms. Farage to warn Mr. King to quote-unquote bring a toothbrush the next time he comes to court, implying that he's going to send him to jail for contempt. Under Section 600.1701 of the Michigan compiled laws, judges have the authority to hold attorneys in contempt for any willful neglect or violation of duty or for disobeying the court. This could include missing a scheduled hearing. Section 600.1711 of the Michigan compiled laws allows judges to punish contempt with a fine, imprisonment, or both. Accordingly, Judge Oakley would likely be within his authority to both hold Mr. King in contempt and jail him as the penalty.
If I may, Judge, I recognize I have no actual power to object to comments from and I recognize that. But the way that this was handled, and it's one thing to go on the team, I have a lot of respect for the defense services. There are several of them here in this courthouse that I have so much respect for.
Me too.
This is completely inappropriate, and I told Mr. King that until it was natural, we were ready to go, and I'm at a loss, Judge, because ethically as a prosecutor, I cannot push to proceed when there is a genuine referral of competency. I don't know how to my evidence, but this is extremely difficult for the position we are in. The reason we're in this position is because of Mr. King. If I may, Your Honor.
Go ahead.
Well, thank you very much for the meeting. But Mr. Lisby, and I can speak to the conversations with the prosecutor at the however, I will just say that at the times and moments Mr. King was stating that he did not intend to escape to happen blind over the moment it wasn't until understanding the actual, not the communications and client confidential conversations that we had, that even after the examination, there was all the things that were possible, that Mr. Littleton has an issue overseeing the order, nature, and procedures, as well as not being able to assist rapidly in his defense. So it's not to say that Mr. King wasn't being honest or truthful, but
He was being lazy and unprofessional, counsel. He never spoke to the defendant. Unless she's lying to me, King told her he'd never met with Mr. Littleton. Other people from his office had.
I wasn't aware of that conversation. I can't speak to that.
Then I'm going to take her at her word.
Just saying that all the time that she was speaking to Mr. King, and he made the applications and the intention of holding this exam, that was his intention. It wasn't to be dismissive. It wasn't a reason to communicate. That he was figuring out.
Counsel, stop, or I'll hold you in contempt.
Just to make my argument.
Keep talking, I'll hold you in contempt. I'm not going to let you make your argument because you don't know what you're talking about. You're not talking from first-hand knowledge. She is. Sit down. Counsel, don't test me. Sit down. You're done speaking today.
Done speaking today?
Yes, ma'am. Who for?
Her name is Nora Alabama. That's spelled N-O-R-A. That's A-L dash.
All right, I'm going to want her in just a minute. Do the paperwork so we can send Mr. Littleton for his competency, which will be 6 months down the road before we hear anything. You guys can take Mr. Littleton back into lockup. Bring your complainant in.
Podium?
Just podium, yeah. Right here, ma'am. Right here. Did you tell her what happened?
I did not. I told her that there was an issue and he wanted to see her and that I would explain as
So we're not going to have an exam today. I wanted to apologize to you personally for making you show up and put you through this and have nothing of substance happen. I also want to know exactly
Do you think they're actually following us?
What it cost you to show up here today. Because if I find the attorney in contempt, I'm going to charge him for your costs. You understand that? I just wanted you to hear it from me personally that I apologize on behalf of the system. I apologize to you because the system is not treating you well.
Hi, Nina.
Thank you, counsel. Is there anything else?
in the again, I just want to acknowledge that I do not believe that Ms. Fresh did anything she was just said.
I don't disagree.
Instead of taking testimony, Judge Oakley ordered a competency evaluation to determine whether Mr. Littleton was mentally fit to stand trial. As of the date of writing this episode, the proceedings against Mr. Littleton remain on hold pending the results of the competency evaluation, with a review hearing scheduled for October 15th, 2025. This hearing illustrates how scheduling pressures and lapses in communication can ripple through the courtroom. When an attorney has not met with a client or is unable to attend a critical proceeding, the result is not only a delay in the case, but also greater uncertainty for the defendant, who must face the prospect of navigating the proceedings without an adequate explanation of the process and the charges against them. At the same time, such circumstances expose the attorney to potential consequences, including the risk of contempt or even ethical violation. Now, while in the context of indigent defense, these difficulties often stem less from intentional neglect than from the challenges of managing overwhelming caseloads and competing demands on time. Nevertheless, the impact on the court and the client is the same. The outcome here shows how the defendant's interests and the attorney's professional responsibilities are closely linked, and how strained time management can lead to setbacks for both. Let us know if there is a case or courtroom interaction that you would like us to explore in the comments below. Thank you for watching, and don't forget to like and subscribe so we can help foster a more informed society. On September 10th, 2025, defendant Jeremy Taylor was arraigned in the 34th District Court in Wayne County, Michigan on a felony firearm charge in violation of Section 750.227B of the Michigan Compiled Laws and brandishing a firearm in violation of Section 750.234E. The charges stemmed from an alleged road rage incident that occurred in April of 2025, during which Mr. Taylor was accused of pointing a handgun at fellow motorist Elizabeth Whirl from an adjacent lane during the early morning commute. On October 15th, 2025, a preliminary examination hearing was scheduled before Judge Brian Oakley, with Assistant Prosecutor Stephen Campbell appearing on behalf of the people and defense attorney Scott Weinberg representing Mr. Taylor to determine whether probable cause existed to bind the matter over to circuit court for trial.
All right, gentlemen, are we ready for appearances on Taylor? This lady's not connected with the case?
She's our witness.
Oh, you're the witness? Come on up. Come on up. Watch your step on my ramp right here. Raise your right hand. Do you swear or affirm to tell the truth, the whole truth, and nothing but the truth today? Have a seat right there. Just make yourself comfortable. Mr. Kaplan, when you're ready.
Good morning. State your name for us.
Elizabeth Worrell.
What do you do for work?
I work at a logistics company out in New Boston.
Taking you back in time to April 23 of this year, 2025, at about 6 in the morning. Do you recall your whereabouts?
I was on my way to work on 625, coming up to my exit to get to work.
What type of vehicle were you driving?
Like a Tana Stray Chevy Star Blazer.
Are you alone in the vehicle or do you have company?
No, I was by myself.
You started to tell the judge about you on I-275 North. Anything unusual happened to you when you were traveling on I-275 North?
I was on my way to work that morning and I noticed that there was a vehicle behind me. The vehicle was very close to the rear of my car. I had changed lanes a few different times. If I'm not mistaken, I changed lanes a total of 4 times.
Tell us about the weather. Was it light out or dark?
It was typical, nighttime, right before the sun was coming up. It was about 5:30 in the morning.
Are you able to tell the judge the color of the other vehicle?
Yes.
What's the color?
It was like a dark gray, dark blue.
Are you able to inform the court the model?
Yeah, it was a Chevy Malibu. License plate was the first EJY.
How do you know the license plate was showing EJY?
Because as he was speeding away from me, as I exited onto my exit to get off for work, he said past me at probably about 100 miles an hour. And I caught the first grade license plate and the description of the vehicle.
Does anything?
Yeah, I'm gonna object to the estimate of 100 miles an hour. She actually can prove how she knows it.
Well, that's a lay opinion. It's really not important to the case. Under 701, that's a lay opinion issue.
Well, that's fine. It's not important why we listen.
Because it's hardly.
Let's move on.
Thank you. Anything more unusual happened while you traveled at 975 North?
When I noticed that vehicle behind me, like I said before, I had changed lanes. The vehicle followed me, and I want to say it was the third time that I had changed lanes. The vehicle followed me again. I did brake check the vehicle behind me, which I know you're not supposed to do.
What happened after you brake check?
You gotta be closer. And so I had moved back into the middle lane, and he was again right behind me, even before.
Anything happened after you changed into the middle lane?
Other than him following me, no, not until I had gotten up to closer to the exit I was getting off at.
Which exit is that?
The West Huron exit.
Anything unusual happened there near that exit?
Yeah, as after I had been followed back into the middle lane, I was just nervous at this point, so I waited until the last possible second, made sure that the lane next to me was clear, and I just booked it right off at the exit, and then that's when the vehicle pulled up next to me.
Anything happened when that vehicle pulled next to you?
I saw the outline of a handgun pointed at me.
How far were you from the person holding the handgun?
The vehicle had moved right next to me in that lane, so.
Can you give us an estimate on the distance? I'm gonna walk towards you with the judge's permission. Can you stop me when I reach that distance?
Probably about right there.
Judge, we directly reflect about, I know I'm short, but sorry.
Ms. Weinberg, thank you.
How certain or uncertain are you that the gun was pointed?
100% positive. I saw the outline of the handgun.
What were you thinking when the gun was pointed?
That I was going to be shot.
But what did you do, if anything, after the gun had been pointed at?
I just got off right at that exit, and when I had looked over, the vehicle next to me had rolled the window down, and when that gun at me, I did see the outline of the gun.
Was the gun pointed at you on one occasion or two different?
Just once.
What do you do after the gun's pointed at you? Do you contact authorities in some way?
I took pulled into work, contacted my wife, and let her know what happened. She told me that
Don't get us what she said.
Okay.
But anyway, you contacted your wife.
Yep, I contacted my wife. I ended up leaving work, and at the end of the road that I work off of, there was a new police officer.
Did you ever contact with the officer?
Yes, I pulled up next to the officer, explained what happened, and asked what I do moving forward, and then that's when, he took my statement and that's all.
I went up to identify the man with the gun. Why not?
It was too dark, I couldn't see the face, the only thing I could see was the outline.
Hey, right.
Mr. Weinberg, your witness.
This must be what Phineas was looking for.
Elizabeth, for
This is my name is Scott White. If I'm asking for questions, if you don't understand, let me know. I'll stop it and I'll rephrase it, okay? Circumstance.
Phineas is
Okay, can you
paranoid.
identify that man, okay?
Maybe it's not all in his
You
mind.
cannot identify my client, Mr. Jeremy Taylor, is that correct?
Objection, it's been asked that he was,
Is that correct? You can't.
it's been an objection asked.
Clarification.
So you have no idea that Mr. Taylor is the man you're talking about?
Do you think they're even looking at the underwear?
And
I highly doubt it.
Is that correct?
Oh my
What
God.
kind of day was
5:30 roughly in the morning.
Do you think they're even looking at the underwear? I highly doubt it.
Next to you was the light of this vehicle.
The lights on the, other side of the freeway, that's how I could see.
Do you think they're even looking at the underwear? I highly doubt it.
The face.
Right. So you didn't see a gun, you saw the outline of the gun, correct? You can't identify the gun, correct? You can't identify the model or the make, correct? You saw an outline of what you thought was the gun, correct?
Of what was gun is.
Well, did you ever touch that gun?
No.
And you can't identify anything other than the outline, correct? Right. Have you ever seen a gun? doing something before? You own a gun?
No, I cannot.
Okay. Have you ever seen the outline of a handgun like this gun before?
Before the Agoras of Rhodes,
To me,
dedicated by Pindaros himself.
handguns for the most part look
2K.
Did you understand?
Always be proud, little one.
it's,
Your
My
father
question
is the
was, did you
greatest
ever
of
see an
Pancratian
outline of that
champions.
specific gun before?
I can't answer that.
Was that a yes or no?
Objection, because you can't even look what?
You testified that.
Do you think they're even looking at the underwear? I highly doubt it.
At some point, you slammed the brakes on in front of him while you were driving, isn't that correct?
Correct.
And that would precipitated this
We object.
No.
Well, excuse me, we don't know what's in the mind of the other person.
That's fine.
So that was a speculation objection? Was that the first incident between you and the other vehicles when you brake checked the vehicle?
That morning, did you make a statement to the board?
Yes.
And again, did you tell them at that time that you could not identify the man or the person who allegedly planted the gun?
Yes.
And did you ever tell the police that you heard this man say anything?
Huh?
So you can't identify his voice either, is that correct?
Correct.
You can't identify anything other than you saw the outline of what you think was a gun, correct?
Correct.
I know that.
Any follow-up? Ma'am, you can step down. Watch your step on my ramp.
On both direct and cross-examination, Ms. Worrell admits that she could not see the face of the man who pointed the gun at her, and that she only saw the outline of the gun. Under Section 766.13 of the Michigan compiled laws, a magistrate conducting a preliminary examination must make two distinct findings. First, that a felony has been committed, and second, that there is probable cause to believe that the defendant committed it. Ms. Worrell's limited ability to observe her assailant bears on both prongs. First, her testimony that she saw nothing more than the outline of what she believed to be a handgun raises a question as to whether the evidence establishes that a firearm offense actually occurred. Additionally, her acknowledged inability to identify the face of the person holding the object means that her testimony alone cannot confirm Mr. Taylor as the individual who committed the act. A judge must find both that a felony was committed and that there is probable cause to believe that the defendant committed it before binding a case to the circuit court. Ms. Worrell's testimony, standing alone, presents challenges on each.
Your Honor, we have one other witness who called him, and that's our trooper, Trooper Jonathan Meyer.
Raise your right hand. Swear or affirm to tell the truth, the whole truth, and nothing but the truth today. I need to settle it. When you're ready, Mr. Campbell.
Thank you, Your Honor. Good morning, Trooper Meyer.
Morning.
Sir, how many years have you worked in Michigan State Police?
13.
Sir, were you working on April 23 of 2020?
Yes.
Can you tell the judge where I-275, your South Huron Road, what municipalities in that area?
New Boston.
In which county?
In Wayne County.
Well, sir, did you have an opportunity to speak to a woman named Elizabeth Rowe?
I did.
She the woman who testified a few moments?
That's right.
Why did you speak to Ms. Rowe?
That would have been on Huron Avenue, right there, just west of I-275. She had left the workplace to come to meet with us there.
Did you know Ms. Rowe before the state?
No,
How long did you speak to Ms. Rowe?
probably approximately an hour.
Can you describe her demeanor?
Shaken, frightened.
How did you become involved in this custody?
Our dispatch center was contacted by the New Boston Police Department.
How much time passed between when dispatch received information about an alleged crime on the freeway and when you met Ms. Rowe?
I'd say approximately 30 minutes.
Trooper Meyer, did you meet a man named Jeremy Candace?
Yes.
Have looked
If you saw Jeremy Candace, did you recognize him? Sometime the courtroom and let his arm know when you see Jeremy Candace.
I do, yes.
What is he wearing and where is he seated?
He is seated next to the defense attorney, wearing a maroon shirt and a finger on his neck.
Noted.
Thank you, Your Honor. Why don't you speak to Mr. Hill?
Mr. Taylor was my suspect, the registered owner of a vehicle matching the description given by the victim.
Well, you provided a license plate, partial license plate now?
That's right.
What, do you remember what that is?
It was EJ Wild, the first three.
Who provided that to you?
Miss Laurel.
In terms of that EJY 275 partial license plate description, did you attempt to determine the owner of the vehicle?
Yes.
How did you do that?
Using our license plate reader cameras in the area, I conducted a search using the criteria provided a partial plate along with a vague vehicle description, and was able to come up with two possible matches to that.
Ultimately, you narrowed the field.
Some of those license plate reader camera photographs taken of that vehicle, I was able to retrieve that full license plate, run that license plate through our law enforcement information network.
And through Lean, did it identify anybody?
I did, yes.
Whom did it identify?
It was Mr. Taylor as the registered owner of that vehicle.
You know his first name?
Jeremy.
Did you make any determination as to whether Mr. Taylor, in fact, drove such a vehicle?
Yes.
And what was the vehicle? Were you able to tell us the color and model and year?
Yeah, it's a blue, I believe, 2009 Chevy Malibu.
Did you at any point advise Mr. Taylor of his brand?
I did, yes.
How did that?
Traffic stop was conducted.
By who?
I did. And I pulled him over on 275 near Eureka. Spoke to him briefly, introduced myself, asked him if there were, or he declared to me, rather, I didn't have to ask, he declared to me that there was a firearm in the vehicle, that he was a CPL holder. Shortly thereafter, I read him his Miranda rights, put him into custody.
So don't go any further.
Yes, sir.
Terms of Miranda.
Yes.
When apprising of such rights, did you do so from memory or from a form?
Just read to him from a form. I read it to him.
Can you estimate for Judge Oakley the number of times you've read Miranda rights?
Perhaps maybe several hundred times.
Did you read some of the rights, all the rights, and none of the rights?
All.
How long did you speak to Mr. Taylor?
Approximately an hour.
Now, after reading of his rights, did you ask whether
Eris has
he wished to
chosen me
speak
to
to a
lead the
lawyer?
Spartans to
Did
glory.
you ask whether he
There
wanted a
can
lawyer or
only
whether
be
he
one.
wanted to remain silent?
Pausanias is part of the cult of
He agreed
Cosmos.
to talk.
I'll have to kill him myself.
Did you offer him any promises of leniency to speak to you?
No.
Did you threaten him in any?
No.
Did he appear to be deprived of food, water, shelter, sustenance, sleep?
No.
During direct examination, Trooper Jonathan Meyer testifies that he advised Mr. Taylor of his Miranda rights prior to questioning, that Mr. Taylor agreed to speak with him, that no promises of leniency or threats were made, and that Mr. Taylor showed no signs of deprivation of food, water, shelter, or sleep. In the 1966 case of Miranda v. Arizona, the Supreme Court held that the Fifth Amendment privilege against self-incrimination and the Sixth Amendment right to counsel require law enforcement to inform a suspect of these constitutional rights prior to any custodial interrogation. These mandatory admonitions have come to be known as Miranda warnings, or reading a suspect their Miranda rights. Under the Miranda doctrine, any statements obtained during a custodial interrogation are inadmissible unless the prosecution can demonstrate under the totality of the circumstances that the suspect knowingly, voluntarily, and intelligently waived their Miranda rights. Promises of leniency, threats, or conditions of physical deprivation can each undermine the voluntariness of a waiver, as they suggest the suspect's decision to speak was the product of coercion rather than a free and informed choice. Mr. Campbell's questions on each of these points therefore seem to be directed at establishing that Mr. Taylor's waiver was knowing, voluntary, and intelligent, and that the statements that he made to Trooper Meyer are admissible as evidence.
Did you inquire as to where his whereabouts earlier in the day, like April 23, 2025, at about 6 in the morning?
Yes, I did.
What did he tell you his whereabouts?
He explained that he was traveling on northbound 275 on his way to work at approximately that time.
Did he indicate where he was headed, where he was coming from?
He was coming from his home and headed to his workplace in Van Buren Township.
Did you inquire on any incident that might have occurred between some vehicles?
I did.
What's the specific question you asked him?
I asked if there was any unusual road rage type incidents that had occurred.
What did Mr. Taylor say in response?
Initially, he denied that there was, saying that something had happened the day prior.
You said initially.
That's right.
What does that mean?
So when I first asked that question, had anything unusual, like a road rage incident happened, he said, no, not this morning. Yesterday, something happened between me and a female in a light-colored vehicle.
Does he give a different answer at some point?
He does, yes.
How does the transition occur?
I asked further questions about that incident. I said, well, there was an allegation that something happened this morning. And then he said something along the line of, oh, maybe that was this. And then goes on to describe the victim's vehicle and somewhat of a road rage interaction between them.
Did he indicate to you any specific actions he claimed that the other woman took?
To my memory, that she brake checked him and flipped him off.
What is flipping off?
Presenting her middle finger to him. Derogatory.
Did you specifically ask him whether he pointed a gun at another woman?
I did, yes.
What did he say?
He denied.
Does he later give an explanation?
He does.
What does he say?
He said that it could have been that what she saw was him pointing his finger at her and then later added that he may have had a coffee mug in his hand at the time he did this.
You communicated to the judge earlier.
Ready the horse.
Let's say you had a conflict.
Yes.
You finding them?
Yes.
Where you located them?
In the center console between the driver's and passenger seat.
How far is that gun from the driver? Where the driver would have been seen?
Directly next to him, within,
The information you had given about
Drop the sail!
previous vehicle, how does it make?
the first three of the license plate match, and also she described the color and model of the along with phone stickers, separate from one to the other.
Only time you went to the side of the vehicle,
The gun was seized from the scene of the traffic.
what is that term?
That means secured and preparing.
How many times on the same console is supposed to happen? Was your report? Sure. Treat yourself to provide safety. You do. Remember, what is your number?
That in fact the firearm in the center
The firearm loaded around you.
Increase speed! Slower now! I need the outcome!
What is your score of weapon to use it for? Gun in his holster or gun in his compass? Thank you, Your Honor. Mr. Weinberg.
Scott Lambert would ask you some questions if you understand something of the script. So you were called onto the scene by other police officers. Who else?
Fight with all your strength, young Spartans!
two Boston.
But this wasn't called, they were driving the scene.
That's correct, yes.
And when you got to the scene, where was
Show us your
That was
strength!
unknown to me at the time.
Yield to me now!
Did you pull up Rail?
Victory is
Did
yours!
you pull him over? You pulled him over because of this match and wait, correct?
That's correct, yes.
Did you first
Show us
approach
your true Spartan strength!
I did, yes.
So was he in the driver's seat?
Yes.
So he, as you testified, first told you, right when you came out, that he had a CPR, correct? Yes, he was obligated.
Throw him, Leon! Use your weight!
I did not see the gun first time.
And in no time, he provided you with the gun, correct?
He did not provide me as in hand me the
Throw
gun.
him, Leon! Use your weight!
So, who actually ended up pulling the gun out of the who found it?
To my recollection, I found it located here.
Do you remember?
Throw him, Leon! Use your weight!
Yes. And I had two other troopers with me, so that's also my recollection. I'm the one who pulled it out.
Throw him, Leon! Use your
And
weight!
did you pull it out before or after you
During that, I don't remember how many questions had been asked of him prior to us.
Throw him, Leon! Use your weight!
But you had already interviewed him, correct? So
I look forward to yes, that's it.
and you read his Miranda.
No.
And at the point did
Throw
you
him,
take my
Leon!
client,
Use your
put him
weight!
in your vehicle, and start discussing this matter in the vehicle without reading his Miranda?
No, he had been read at the right time.
And you
Throw
read
him,
it
Leon!
once,
Use your
correct?
weight!
When you first arrived at the scene, is it true that you took him out of his vehicle and had him sit in your slot, correct?
I don't recall
Throw him,
at
Leon!
when
Use your
time
weight!
frame he sat in that vehicle, but he did sit in that vehicle. That's right.
Is that his management or is it after?
I don't recall.
Do you recall getting a
Throw him,
statement from
Leon!
him
Use
after
your
he
weight!
was there? And do you recall your conversation with your spoke?
I do.
You involved the questions and the comments you made to him when you were in it?
Not every comment, no, you're not.
You know your conversation.
Ready the horse!
And do you recall telling him the rendition of what she had told you, or written understanding of what she had said? And that there was some type of pointing the gun at her threat?
Right.
Do you recall telling him that there was evidence to show that he actually did point the gun at her from a video film?
That's
Do you have any evidence of
no,
this? So you lied to the gun.
yes, sir.
And is it your practice to lie in your investigation?
Objection, he's allowed to lie.
I'm asking you.
He can be Pinocchio because of the answer. say whatever he wants.
I understand that, and I agree with you, but that doesn't mean Mr. Weinberg can't ask him questions about it.
On cross-examination, Trooper Meyer acknowledges that during his interrogation of Mr. Taylor, he falsely told him that video evidence existed showing Mr. Taylor pointing a gun at Ms. Whirl, when, in fact, no such evidence existed. When Mr. Weinberg presses Trooper Meyer on this directly, Trooper Meyer confirms that he lied. Mr. Campbell objects to the line of questioning, noting that law enforcement is permitted to use deception during interrogations. Judge Oakley agrees that officers are legally allowed to lie to suspects, but overrules the objection, permitting Mr. Weinberg to continue with his questions. In the 1969 case of Fraser v. Cup, the Supreme Court considered the implications of police deception during interrogation after officers falsely told a murder suspect that his alleged accomplice had already confessed and implicated him, prompting the suspect to make incriminating statements of his own. The court held that while the police misrepresentation was relevant to the voluntariness analysis, it was insufficient on its own to render an otherwise voluntary statement inadmissible, and that such questions must be resolved by viewing the totality of the circumstances. Under that framework, Trooper Meyer's false claim about video evidence did not automatically require the exclusion of any statements made by Mr. Taylor, but it became one relevant factor that a court would weigh when evaluating whether his decision to speak was truly knowing, voluntary, and intelligent.
So is the practice to lie to a suspect during the
We
proceedings?
have to that question. It doesn't matter what his practice is. If somebody lied, we lie all the time. It's not wrong.
Relevant to it.
It's not only relevant, it's also goes to his experience and his practice. The prosecutor is excruciatingly detailed about how many types of stops he had, and he's had 9 types of investigations, and how he knows practical to have something on his hip, it's holster, or not. I just want to find his practice in terms of interviewing ways.
You're correct, but I'll allow it.
So they have to practice the lie to a suspect while they're doing this.
It's not necessarily practice.
But you chose to do it in this.
Yes.
Isn't it because Ms. Worrell could not identify him? Is that right?
I'm sorry, what was the...
You had told him to lie to him that there was evidence to show that he pointed the gun because she could not identify him. Isn't that right?
I'm struggling with it.
So let me rephrase. Why did you lie to my client? The picture showing that he, the picture that didn't make sense, showing that he pointed the gun.
Objection, obviously, it doesn't dispute anything in the
Hey, what's relevant? Well, I'll take judicial notice that it seems to have worked, if that helps.
Well, did he say that he actually did point it out?
No.
So he denied it.
That's right.
At any time, before you read his Miranda rights or after you read his Miranda rights, did he ever say that he did it?
He did not.
He did say that he might have pointed his finger or a cup, isn't that correct?
That's right.
And Mr. Pierre, Ms. Worrell,
I did.
and you,
Judge, you can't comment on what cases.
I did that's what that's what he did.
That's not wrong.
He signed Ms. Worrell saying she saw an outline of the gun. Is there any evidence you collected? Do you recall that your SWAT car had a video on the set?
It does, yes.
And you recall that I recorded any conversation with my client in your vehicle?
Yes.
And you recall whether and you reviewed it?
It's been some time. I reviewed it either that day or that week.
There's your sworn testimony that prior to visiting my client in that vehicle or outside the vehicle, or any time that day, that you read it for injuries.
Yes, I let him.
I have no further.
Mr. Kaplan, any regret?
Can you demonstrate the question? Did the defendant make any gesture where you described possibly putting his finger on the moment?
He did, yes.
Can you show the gesture?
Yes. He said that he may have pointed his finger and did something like this.
So, for the record, can we agree that the trooper has stood up and pointed his index finger with his thumb closed? A nap description? Go ahead. Any reprops? Trooper, you can step down. Watch your step on the ramps. Any defense witnesses? Argument?
In this case, the witness says the gun is pointed at her. Could she be mistaken? Yes, it could be mistaken. The question is the probable cause of the pointed at. She seems certain, Judge. Despite a very effective cross-examination by Mr. Weinberg, she said that was a gun. I said, well, I did not have seen guns. That was a description. Now, in terms of who the culprit is, whoever did this, Judge, I believe it is a dark-colored Chevrolet Malibu with the first three digits of the license plate being PJ5. Now, think about it, Your Honor. Think of the coincidence if he's got the one down. I mean, somebody else driving a dark-colored Chevrolet Malibu in that area on I-275 North. Think of the likelihood of this license plate being PJ5 and it being a dark-colored Chevrolet Malibu. And he had a gun in the car. It wasn't close. Now that's important. It's relatively suspect. This was a low-grade incident that spiraled out of control, and it's very unfortunate. Unfortunately, nobody was in. And the finger? Maybe it was my finger. That's not something you forget, Judge. But wasn't there something in the interview? Weeks later? Yeah, maybe I had quite enough finger. We would ask around to find the source, Judge.
Mr. Weinberg.
Well, you can't just be, you could be mistaken. This man is charged with a 40 felony and a mandatory 2-year felony felony firearm. We better have more than simply, she could be mistaken. She did not identify a gun. They had no pictures of a gun. They've never identified any gun that she identified. They never had any evidence saying, yes, that's the gun that was used, or this is what the gun looked like. It was an outline of a gun, which she readily admits is too dark even to identify my client. It was 5-something in the morning. There's no lights on, maybe some street lights. She has an extremely weak testimony. And someone can drive up and say that they actually saw something develop when they get a charge for this. So I disagree with this experienced prosecutor who said in thousands of these cases that there is enough evidence to find the criminal. Maybe if they have a gun. Maybe if they have, or even identify my client as the driver of the car, but they don't have that. So I'm asking the court to dismiss this.
Good.
But in reviewing the case, you're determining whether there's probable cause.
Come,
The steps to the Parthenon are long and
I don't see any way in hell of getting a conviction, but the probable cause burden has been met. I'm tempted to dismiss it just so we don't waste any more judicial resources, but that's not my role. I'm going to bind it over. October 29, 9 a.m. Bond will continue. Good luck downtown, gentlemen.
At the close of the preliminary examination, Judge Oakley found that the prosecution had met the probable cause standard and bound the matter over to circuit court, though he remarked from the bench that he did not see any way the prosecution would obtain a conviction. The case was subsequently transferred to the 3rd Circuit Court in Wayne County, where it was assigned to Judge Shannon Walker. On December 17, 2025, Mr. Taylor entered a plea of nolo contendere to the charge of brandishing a firearm in public, and the felony firearm charge was dismissed. Judge Walker sentenced Mr. Taylor to 2 years of probation, 160 hours of community service, and court trial. This hearing highlights the gap that can exist between what the law permits and what the public might expect from those sworn to uphold it. Trooper Meyer's admission that he lied to Mr. Taylor during interrogation may strike many as fundamentally at odds with the expectations that we place on law enforcement, and yet his false statement was entirely permissible under the existing legal framework. The law draws the line not at honesty, but at coercion, and as long as the suspect's waiver of his rights remains quote-unquote knowing, voluntary, and intelligent under the totality of the circumstances, the fact that an officer deliberately lied to a suspect is subject to far less scrutiny than many citizens might assume. The permission to deceive suspects reflects a deliberate policy choice, one premised on the idea that dishonesty in service of investigation is meaningfully distinct from coercing an involuntary confession, though where exactly that line falls has never been a question with a clean or universally satisfying answer. What the law permits and what feels moral and just to the majority of everyday citizens do not always converge, and police interrogations are one area
Makes no
where
sense.
that tension is most plainly visible. Let us know if there is a case or courtroom interaction that you would like us to explore in the comments below. Thank you for watching, and don't forget to like and subscribe so that we can help foster a more informed society.
Throw him, Leon! Use your weight!
Bisa dari Linda.
Do you think this is funny?
I'm allowed to laugh.
The arrested for laughing case. I'm the lawyer on that civil rights lawsuit, and just last night we got a ruling finally on whether or not that police officer gets qualified immunity. He got pulled over here in West Virginia for flashing his headlights at oncoming motorists in order to warn them of a notorious speed trap.
Socrates!
That wasn't a crime, so the officer basically made up a citation, and when he went to give it to my client, he laughed.
And I could take you to jail today for your unsigned registration card, but I just wrote you a citation for that. That's actually up to 6 months in jail. You think it's funny, sir?
The officer didn't like that. He pulls him out of the car. He ends up putting him in handcuffs.
Step out of the vehicle.
Are you serious?
Place your hands behind your back for me.
Are you serious?
Yes, sir. Place your hands behind your back for me.
Oh, man, you're serious, brother.
I'm not your brother.
I've seen on some of the viral videos floating around the internet all sorts of claims about what actually happened in that case. But they're all wrong. I'm litigating the lawsuit, and it's actually still pending. But there's a huge update. After we filed the lawsuit, that officer and the sheriff of that county asked the federal court to dismiss it and to give the officer qualified immunity, claiming that the driver had no right to warn others about a speed trap and also had no right to laugh at the police. And the court answered those questions. Did he get qualified immunity, or did the court deny him qualified immunity? I recently realized that I had no idea how many subscriptions I had on different devices and had no idea how much they were costing me every month. I was actually shocked to find out how much it was. At least once I was able to finally track them all down and add them all up. How great would it be if you just had an app that would keep track of all of that for you? That's why I love this video's sponsor, Rocket Money. Rocket Money is an all-in-one finance app that helps you save more and spend less. It helps you manage subscriptions, lower bills, build a custom budget, grow your savings, all in one place. But my absolute favorite part of using Rocket Money is to cancel unwanted subscriptions. It securely identifies recurring charges and allows you to cancel these with just a few taps. You never even have to get on the phone. They do it for you, and they've helped customers save over $500 million in canceled subscriptions. So if you want to save more and spend less, go now and join the over 5 million members using Rocket Money. And here's what you do. Go to rocketmoney.com/civil or click the link in the description to get started for free. You can also unlock even more features with premium. That's rocketmoney.com/civil to get started for free. Thanks again to Rocket Money for sponsoring this video. Now let's get back to it. This video is about the actions of Nicholas County, West Virginia Deputy J.D. Ellison. The county seat of Nicholas County is Summersville, West Virginia. For many years, the four-lane highway, Route 19, that runs through or next to Summersville has been known as a notorious speed trap. In fact, in footnote 1 of the court's order that I'm going to tell you about in this video, the court took judicial notice of the fact that this incident happened at the site of a notorious speed trap. I even found some news videos going way back discussing the fact that this spot is a speed trap.
Ever get a speeding ticket you didn't think you deserved? Well, this is the story for you. It's about Summersville, West Virginia, a town that likes life in the slow lane. So much so, it's known as the speed trap of North America, handing out thousands of tickets a year. For Canadians, there's one fatal bump on the road to the winter respite in the U.S. South. And it's here, amid the rolling hills of the Appalachians, where the local law patrols its turf rigorously, assiduously, unrelentingly. Though they don't Canadians specifically. No. They'll write speeding tickets to anyone passing through.
Hello, man. Have you uploaded some registration there? Okay.
Abandon hope, all we who enter here. Here being an otherwise tranquil little community of 3,000 or so souls, nestled alongside a roadway, very popular with thousands of Canadians traveling back and forth on Florida vacations.
Police back then, they were much kinder when they were on camera to the Canadians than they were to William Iannacone, who was the guy that this happened to, who originally brought the footage. William Iannacone was driving through this notorious speed trap, this stretch of US Route 19 on May 13th of 2022. While doing so, he noticed a parked police car that was running radar and matched suspicious limits. So he decided to send a warning to the oncoming motorists that they were about to cross the officer. To send that message, he began flashing his headlights at the passing cars. As the court wrote, his message got through to the oncoming motorists, but unfortunately for him, Deputy J.D. Ellison was one of the recipients of that message. Ellison, a deputy at the Nicholas County Sheriff's Department, turned his vehicle around and initiated a traffic stop. In his body cam footage, Ellison can be heard talking to another officer, presumably the one that was running the speed trap, notifying him that he caught the plaintiff doing this and that he was apparently to pull him over.
Ridiculous. Dun, dun, dun,
Flashing your lights at everybody to let them know that law enforcement was sitting there running radar. Is that what I did?
I don't play games with people's lives. I play video games, but life is serious.
Why would you do that?
Officer why he did it. He admitted to Mr. Iannacona why he did it. That's really not in dispute. The driver then explained to the deputy that he was unaware that flashing his headlights as a warning to other drivers was illegal.
I think they're trying to hide anger and emotions, but they aren't.
Yeah, you can't hide from people at any time in the daytime or nighttime. I'm sure I could articulate some other kind of charge in there for doing that too. That's pretty crappy.
Citizens just need to mind their own business. Quit getting involved with people who are fighting on the street.
He proceeded to write out 2 citations to the for violating the special restrictions statute, whatever that is, and another
Fine.
It says no flashing lights on a vehicle, and at that point in time, you had flashing lights on your vehicle. It's unauthorized.
Well, under the Constitution, it's protected in the First Amendment. But I'm going to look into it.
That's in Tennessee.
Yeah, I'm going to look into it and see about that.
Yeah.
Free speech.
Muddy
It's not illegal
Probably
to do
came from
that.
someone in the garden.
To flash and warn, but it's illegal to high beam, and it is legal to have flashing lights on your vehicle, not being an emergency vehicle. Huh?
I said also.
Okay.
Before he gave the citations to the plaintiff, Deputy Ellison proceeded to extend the traffic stop. He began explaining to Mr. Iannacona that the maximum penalties for an unsigned registration card included 6 months in jail, and that he could arrest him instead of giving him a citation. The driver, apparently finding this suggestion absurd, began laughing. That then infuriated Ellison, who immediately retaliated by ordering him to get out of the vehicle, and then he placed him in handcuffs
There's a
and led him
cave.
back to the cruiser. During this exchange,
See?
Deputy Ellison took
Happy little trees, happy little accidents sometimes lead to better outcomes. I want to burn the
But
vines.
I just wrote you a citation for that. That's actually up to 6 months in jail. You think it's funny, sir? I know. Do you think this is funny?
I'm allowed to laugh.
Sir, I'm asking you to step out.
Cops with egos.
Step out of the vehicle.
Are you serious?
Place your hands behind
Because he
your back.
laughed. Oh my god.
Oh man, you're serious, brother.
I'm not your brother.
Yeah, clearly.
Yeah, I'll never be your brother.
Oh my God, what an asshole.
Don't jerk away from me.
My wallet is in the car.
Okay, I don't want you to jerk away from me.
I was going away from the traffic.
No, I was putting you in front of my car.
Okay.
Which is away from traffic.
You're arresting me for laughing.
No.
I didn't do anything.
I'm arresting you for unsigned registration.
Okay, all right, that's fine.
Okay? So stand right there. Hang tight in front of my vehicle for me. Hang tight right here in front of my vehicle for me.
The plaintiff was then forced to stay in handcuffs for several minutes along the busy Route 19 before eventually Deputy Ellison finally released him after speaking in his car with an unnamed prosecuting attorney.
I guess I'll see you in court. Unsigned registration card. I gave you till the 23rd of this month to contact the magistrate. Phone numbers on the there. Once you contact them, they can tell you how to take care of it. Okay. Alrighty, sir. Be safe.
He brought the original video to me. I helped him find a criminal defense attorney. I did an update video on it after he beat the criminal case on appeal, actually. Since then, I filed a federal civil rights lawsuit. That police officer asked the federal court to grant him qualified immunity, and the ruling just came out last night. By the way, this is what Deputy Ellison's boss, the elected sheriff of Nicholas County, West Virginia, this is what he had to say about the video that you just watched of what he did to Mr. Iannacone. He specifically addresses this video. So listen to what he says, and then compare his words to the court's opinion.
Another topic I would like to cover is incidents regarding one of our other deputies, Deputy Ellison. There's been a live video circulating regarding a traffic stop that resulted in citations being issued. During the stop, the individual began laughing at said officer because of flashing lights and trying to warn other drivers of what could have been a high priority investigation. Examples: trying to locate a missing child that's been abducted, murder suspect, someone bringing poison, drugs into our area that possibly get into our child's hands, trying to find an offender running the stoplights. We all know that's a current problem in our area. When someone acts irrational, it is not normal and raises questions for further possible involvement in criminal activity. He was detained for a short period, then released with citations of what the officer believed was a violation. Further add to the prosecutor believed a violation also occurred, resulting in a hearing where a magistrate convicted and believed one occurred also. The case was then appealed to the circuit court before Judge Callahan, where he overturned the ruling. I will say I believe the wheels of justice was served. And this, folks, is exactly why we have the best justice system in the world. Nowhere else in the world has this type of accountability and freedom. It is not perfect. However, it is very rare that it fails the citizens of this country. I also say as individuals, none of us are perfect. There was only one. Mistakes are made daily and addressed accordingly. As to the officer involved, he has received counseling not only from myself, but my chief and his immediate supervisor. Our office has the utmost respect for our prosecutors, magistrate, and judges. They do an outstanding job for a community. 100% right.
That was the sheriff's opinion, but here's the opinion that matters so far, and that's from the federal courts. As applied to these specific facts as alleged that I've just recited to you, the court held this. Plaintiff contends that Deputy Ellison stated he initiated the stop because plaintiff was signaling other drivers of the presence of another officer. There does not appear to be a law in West Virginia that criminalizes such behavior. Taking the facts as the court must in the light most favorable to the plaintiff, Deputy Ellison allegedly initiated the stop without reasonable suspicion. Such a stop would violate the Fourth Amendment. The court explained that unconstitutionally extending a stop by even a de minimis amount of time violates the Fourth Amendment. So even assuming a valid traffic stop exists, police officers cannot extend that stop any amount of time, or they violate the Fourth Amendment. The court said by failing to hand over the already written citations and prolonging the encounter, Deputy Ellison arguably made the stop longer than necessary to effectuate its purpose. Regarding the fact that Ellison ordered Mr. Iannacona out of the car, the court said, while it is true that an officer may order a suspect out of the car during a valid Terry stop, such order is only valid if an officer possesses an articulable and objectively reasonable belief that the suspect is potentially dangerous. The defendants cite nothing to suggest that between initiating the traffic stop and plaintiff's laughter, that Ellison noticed anything that would suggest the encounter became dangerous to him. Without such justification, the act of ordering plaintiff out of the car is arguably unjustified. And regarding the frisk of the plaintiff, the court said, again, there is nothing to suggest at this time that Deputy Ellison became aware of an evolving threat to his safety. Thus, even assuming this was a frisk of the plaintiff, it was arguably unjustified based on the facts alleged. So I've told you many times that police officers forget that element. In order to pull somebody out of their car and frisk them, there has to be facts objectively available that the individual is armed or dangerous. And in many cases, that does not exist, just like here. In many cases, that's used as sort of a retaliation for perceived disrespect. The defendants argued that there's no First Amendment right to flash your headlights and warn oncoming motorists about a speed trap. Here's what the court said about that. Given the fact that plaintiff contends that Deputy Ellison knew and understood the message he was attempting to send, the court finds no reason to conclude that flashing one's headlights do not constitute protected speech. Moreover, initiating a traffic stop because of protected speech and without probable cause would certainly deter a person from engaging in that protected speech in the future. Regarding qualified immunity, the court said this. Defendants assert Deputy Ellison is entitled to qualified immunity because it is debatable and thus not clearly established that flashing one's headlights to warn other motorists is protected speech. That assertion, however, misses the point. Every reasonable officer in the United States is aware that retaliation for First Amendment speech is a violation of a person's constitutional rights. Whereas here, the allegation is that a defendant knew of the speech and reacted to it accordingly, qualified immunity cannot serve as a proper shield. If just as plaintiff alleges Deputy Ellison knew of plaintiff's speech, had no probable cause to initiate the stop, and stop plaintiff anyway because of that speech, then the actions make out a classic First Amendment retaliation claim. Thus, the court denied qualified immunity to Deputy Ellison. Also, the court said qualified immunity is not applicable to the officer's decision to order Mr. Iannacona out of the car and handcuff him, because it's clearly established that an officer may not arrest an individual either absent probable cause or with sufficiently provable retaliatory animus. In other words, police officers are supposed to know they can't arrest people just for their engaging in protected speech like flashing headlights. So there you have it. Like you heard in the sheriff's video where he tried to gaslight the public and claim that there was some legitimate public safety threat because this man flashed his headlights. He knows the real reason that Mr. Iannacona stopped. Everyone knows the real reason, and the fact is that flashing headlights, whether the Supreme Court has recognized it yet or not, is a physical act among many, many others that are described by case law that can be protected speech. And in this case, as we've alleged, it was intended as protected speech, and it was received by the officer as protected speech, and he admitted that several times during the body cam footage. And that protected speech made him mad, so he retaliated. So this is just the motion to dismiss stage, which is based on the allegations made in the complaint. The court will address all of these issues again at the summary judgment stage, which will include the testimony of the individuals and all other evidence, including the video footage. We're still in the discovery process, that's still happening, but I anticipate the facts will show as we've alleged because it's all on video. It doesn't really matter if anyone disagrees with that. Therefore, no matter what you've seen on any viral video, this is a pending case. These things take time. Sometimes it can take years. Depositions are actually coming up in this case, and then we'll go to court again. And after we get a court order at that point, I'll hopefully give you a positive update at that time. So if you want to follow along, please subscribe both here and at the blog at thecivilrightslawyer.com. You can also follow me on X at JohnBryanESQ. Remember, our rights don't end where your fear begins. Freedom is scary. deal with it.
Hello, I'm Officer Smith. I stopped you, didn't I? You got no inspection sticker on the car.
This is my client DJ. He was driving his crappy little farm car to the store to get some feed for the pile of animals he and his wife have at home. But he gets pulled over, even though the only thing he did wrong was not have an inspection sticker on this crappy little car. He ends up getting arrested, going to jail, and being prosecuted as a drug dealer. How did that happen?
Why are you so shaky? Look at your arm. It's trembling. Is there anything illegal in the car?
You got anything illegal on you?
Martinsburg, does the county have a canine working today? Hey, I'm gonna tell you what, Mr. Beard, go and step out of the car for me.
Did I commit a crime?
Step out of the car. Step out of the car. Martinsburg, send me another unit. He's refusing to step out of the car. Get out of the car. Get out of the car.
Now this young rookie cop, only out of the academy about 3 months, thinks he's caught some sort of drug kingpin. He ordered a drug dog, even before ordering DJ out of his car. Even though DJ never refused to get out of his car, he's yanked out and arrested, put in handcuffs, and put in the back of the police car. From there, he witnesses the scam that these cops are running.
Can we get a canine sniff, please? Yeah.
The supervisor can see that the dog is not interested and he knows what's coming next, so he turns away so his body cam does not capture what's about to happen. But the rookie doesn't know to turn away and he films it.
Throw him, Leon! Use your weight!
Even though the dog was not interested in the car, the handler called his attention over, whistled at him, and tapped on the car, then gave the dog a treat when he reacted to the tapping. That's the scam. And the supervisor tells DJ that the dog alerted, but DJ saw what happened.
So the dog gave a positive alert for
I'm sorry. There's nothing illegal. I've never done drugs in my life.
There's no illegal.
Nah.
So to get the key, I need to find the commander files. This shovel looks recently used.
That was used as the justification to go through all of DJ's stuff. And while doing so, that same supervisor mocked the whole situation while talking to the dog handler, and they both laughed about the scam they just pulled on DJ, and about the fact that DJ saw it, and they don't even care.
I said, canine in the car. He's like, yeah, I saw him tap up there. Wait, bitch, shut up. That's what he said.
Oh my god. These cops really need to be fucking retrained.
About a year ago, I asked
my god.
Well, we did file a lawsuit. Just a few weeks ago, I took depositions of this officer and also the young arresting rookie officer. And that answered a lot of questions about how this innocent guy got dragged through this whole thing and wrongfully arrested and wrongfully charged. I'll show you what the key violations are, because this could happen to you or someone you love, and you need to understand your rights.
Understand your rights.
Fighting for justice often means that I'm on the move. Recently, I found myself in a bit of a bind while traveling. Picture this, I'm out in the middle of nowhere. My phone's data roaming.
Talking about war supplies.
Then there's no Wi-Fi in sight when I needed to make an important call about a case. That's when I wished I had Heatlh, the new eSIM service by Nord Security. Let me tell you about my experience. On my last trip, I decided to give Heatlh a try. Setting it up was a breeze. No more fumbling around with tiny SIM cards or worrying about losing them. I just downloaded the app, chose a plan that fit my travel needs, and within minutes, I was connected. With Heatlh, you get instant connectivity. No waiting for a SIM card to arrive or standing in line at the airport. You just scan a QR code and boom, you're online. And the best part? You get to keep your number for the regular calls while using Heatlh for data. It gives you high-speed data, and you can use it from anywhere in the world. Plus, it's perfect for those of us who value privacy and security thanks to Nord Security's expertise. Now, for you watching, here's a special deal. Use my unique link, Heatlh.com/civil, and enter the coupon code CIVIL. The first 5,000 of you will get a 1 gigabyte data plan for free. Yes, free. It's perfect to test out on your next trip or even locally if you're just curious. Be prepared, stay connected, and keep fighting the good fight with peace of mind. Check the description for the link. Use the code CIVIL and join the Heatlh family. Safe travels, and now let's get back to the video. This stop happened in Martinsburg, West West Virginia, a young police officer with the Martin.
What happened to his body?
Pulled DJ over in this mattress store parking lot. It was a lawful stop because the crappy little farm car that DJ was driving
Never
did not
heard
have
anyone.
a valid inspection sticker, which is required in West Virginia.
Just talking to myself.
Hello, I'm Officer Smith. I stopped you today, man. You got no inspection sticker on your car.
Yeah, I know. We're working on it.
Okay.
Hear the exhaust.
I do. I got you. You got your license, registration? Why are you so shaky? Look at your arm. It's trembling. You have anything illegal in the car?
Even though this traffic stop right now is completely legal because there was reasonable suspicion that there was a violation, and that was the lack of a valid inspection sticker. It's still a seizure under the Fourth Amendment, and the Fourth Amendment requires that any seizures be reasonable, both lawful at the inception and also reasonable in relation to the actual purpose of the seizure, the purpose of the stop, the inspection sticker. Here, despite there being a lawful stop, it goes terribly sideways because this young officer immediately pivots from investigating an inspection sticker to all of a sudden a drug investigation. It all seems to have begun with this bizarre question, why is your arm shaking, when it clearly is not shaking. You can see from several views.
Why are you so shaky? Look at your arm. It's trembling. You have anything illegal in the car?
Now, at the officer's deposition, I asked him, what part of Mr. Beard's body did you observe to be shaking? He said specifically his left hand, whereas in the video, he said arm, and he appears to have pointed at the right arm, which is the only possible appendage that could have been shaking.
Look at your arm. It's trembling.
And then he asks him if there's anything illegal in the car. And DJ listened to it. He actually said no. And then asked, do you have anything illegal on you?
You have anything illegal in the car?
No. You got anything illegal on you?
So he answered the question, said he did not have anything illegal, and then he, using sarcasm, criticized the officer for asking him a dumb question. Now, they are allowed to ask questions that are unrelated to the reason for the stop, so long as they're not prolonging the stop or extending the stop with these other unrelated questions.
You have registration and insurance on the car?
Yeah, I do.
Okay, I need to see those.
On it, because I don't think it's in there. So,
Martinsburg, does county have a canine working today?
This is important. Even before the officer ordered DJ out of the car, he called for the drug dog over the radio.
That's a cool statue. Rawr.
That's significant. When I asked the officer at his deposition, what was it about this traffic stop that made you want to order Mr. Beard out of his car? His answer was this. Really, I guess the totality of the circumstances. Everything from me seeing his arm being shaky, not wanting to give me his registration, even attempt to locate it for me. Him searching the glove box made me uncomfortable because I couldn't really see over into the glove box what he was reaching for. But you just saw in the video that DJ never refused to give his registration. He said he didn't think he had the registration, but that he would look for it. Then as he said he would look for it, he opens the glove box clearly to look for it, and he begins to look for it.
You have registration and insurance on the car?
yeah, I do.
Okay, I need to see those.
on it, because I don't think it's in there. So,
Martinsburg, does county have a canine working today?
So it's not true that he refused to give his registration. He was in the process of looking for his registration, which had been requested. He was trying to apply. Commonly, we keep our registration in the glove box. But now this officer, after the fact, is claiming that the reason he wanted him out of the car is because DJ was searching around in his glove box, and that was suspicious. It made him feel unsafe. Clearly, the video footage does not match up with his sworn testimony.
Hey, I'm gonna tell you what, Mr. Beard, go and step out of the car for me.
did I commit a crime?
Step out of the car. Step out of the car. Martinsburg, step out of the car. Get out of the car. Get out of the car. You're under arrest for obstructing. You're under arrest for obstructing. I told you to step out of the car. I told you once.
What crime did I commit?
You don't have to commit a crime for me. Have you step out of the car. Give me your other hand. Give me your other hand. Give me your other hand. You're videotaping, that's fine. I'm videotaping too, man. When I asked you to step out of the car, you were required by law to step out of the vehicle when asked by the negative. I told you I said for dead inspection, well, no inspection, actually. You're acting very nervous, you're shaking for my officer's safety. That's why I had to step out of the vehicle.
I got a very hurt horse that I'm getting ready to take care of.
Orangeburg, I'm 95 with him.
This is crazy.
You have any weapons on you?
No, it's my knife.
Yeah, I'm sure. Look, man, you turn this into something you didn't do.
And I'm just asking, I have nothing to hide. I have nothing to hide at all.
All right, well, I told you what's going on. I stopped for inspection today.
I understand
when I asked you to
that.
step out of the car, you have to step out of the vehicle.
Okay,
You have to step out of the car.
I disagree, but...
I know you may disagree, but that's the law. You get what I'm saying? Spread your feet. All right.
This officer later told the canine handler from the sheriff's department, who subsequently arrived, when he asked him what did you arrest him for, this is what he said.
What did you arrest him for? So I said, step out of the car.
Best stay on the
I didn't commit a crime. I don't need to step out. Step out of the car. No, I don't need to step out. Okay, you're under arrest. So, obstructing.
So he tells the canine handler that DJ said twice, I don't need to step out. No, I don't need to step out of the car. Let's look back at what actually happened.
Hey, I'll tell you what, there's two big ones. Step out of the car for me.
Did I commit a crime?
Step out of the car. Step out of the car. Step out of the car. Get out of the car. Get out of the car. You're under arrest for obstructing.
Let's look at his police report. So this is the narrative that was included in the charging document that is submitted under oath to the court by this officer. And this is what he wrote in that report. Mr. Beard refused to exit the vehicle and told me he did not commit a crime and would not exit the vehicle. But the video shows that DJ did not say that. He questioned the officer's authority and did not refuse to get out of the vehicle. He was basically yanked out very quickly.
Let's ask what crime I committed.
I can have anybody I want to step out of the vehicle. Okay, I'm not doing this. Okay, well, this is my lieutenant. Feel free to ask me any questions.
I just asked what crime I committed to be taken out of the car, that was all.
Pennsylvania versus Mims says we don't have to tell you. We can take you out of the car for any reason
I
whatsoever.
had a case law that said not, but that's all I was asking while I was asking to be stepped out of the car for,
All right, I just provided the case law to you.
for that was all.
Prove it how you want.
All right, buddy. Walk back to my car.
We see that the key word here
This
that
must be
they've been
Thespies'
teaching
house.
cops is Pennsylvania versus Mims, and they like to use that word. But it's always apparent that they never actually read that case. They never actually learn the case law pertaining to Pennsylvania versus Mims. Because Pennsylvania versus Mims only means that this officer can still perform his routine traffic stop, but just with DJ standing outside of his car rather than sitting inside. Whereas the officer in this case appears to have been misusing Pennsylvania versus Mims to engage in a drug investigation where he's pulling the individual out of the car and frisking him. And Pennsylvania versus Mims does not allow for that. So remember, the traffic stop that was supposed to be occurring was for the inspection sticker issue. I asked him at his deposition, at any point, did you actually begin the process of issuing a warning or a citation for the inspection sticker issue? He said, I believe I did. When? When was that? Answer, I believe it was after he was already arrested. So there was no routine traffic stop occurring. He also admitted during his deposition that in a routine traffic stop for an inspection sticker, he would not pull somebody out of the car. He'd get their information and then he'd go back to his car and he'd write the ticket. None of that happened here. But what did happen, and remember I told you this would be important, he had already called for the drug call prior to ever ordering him out of the car.
I don't like
no
that
wonder
one.
That DJ was surprised by this and wondering, well, what crime did I commit that you're ordering me out of the car? He was being suspected for some sort of drug crime and not for any legitimate reason. The police report says that he arrested Mr. Beard first and then he called for the canine. When I confronted him about that at his deposition, he said he admitted that was false. I said, so the part of your report that says you arrested him for obstruction and then you called the canine, that's false? He said, yeah. Yes, sir. That was a mistake. A typing mistake. After discovering that you had made that mistake, did you ever go back and correct the narrative? No, sir. To be truthful, I didn't know that the narrative was inaccurate until, I guess, past when I would be able to go back and fix it. The point is that this is one of the scams that cops run. If you express any criticism of them, or if you question their authority at all to do something, which you have a First Amendment right to do according to the Supreme Court, they are going to retaliate against you. And this is one of the main ways where they can do that. They know that they have this right to get you out of the car during a routine traffic stop, Pennsylvania versus Mims. But they take it to another level that they're not allowed to do. And they do it very quickly. And what happened to DJ happens all the time. If they perceive any disrespect, any pushback, any questioning at all, they go ahead and order you out of the car and then very quickly, physically and forcibly pull you out of the car, really not even giving you an opportunity to refuse or to get out. This is them abusing that Supreme Court holding to, under the guise of officer safety, to perform a false arrest. So that's the goal, is either to retaliate against you, we're going to do this the hard way now, or to set up an arrest. Oh yeah, he didn't get, and we can see how that happens, because as soon as the other officers arrive, he says, oh yeah, well, he repeatedly refused to get out of the car. And on the police report, oh, he said, I'm not getting out of the car. And thank God the body cam footage shows the truth. And that's why, there ended up not being any conviction here, because the police report was false. I mean, it had a lie in it. It had a false statement in it. What he said at the scene was false. That was a lie. That did not occur. He was wondering why he was having to get out of the car when he was supposed to be in a traffic stop for an inspection sticker. This man had no chance to get out of his car. This had nothing to do with an inspection sticker. This was just pure retaliation. And you can see that to prove that, you have to go into the weeds and nail these people down like happened here. All right, so here's step 2 of the scam that not only happened to DJ on this occasion, but happens all over the country every day. The scam is that cops bring a drug-sniffing dog to the scene. What they need to search your vehicle is probable cause. The courts have said that if this trained drug-sniffing dog circles your car and signals that there's narcotics in the car, that is probable cause to then search the inside of your car. This is what they want to do. And as you'll see, they're not going to take no for an answer from the drug-sniffing dog.
Well, see, he was shaking horrible. So I was like, anything illegal in the car? I said, do you have anything illegal on you? And I was like, okay. You have anything illegal in the car?
You got anything illegal on you?
I was like, anything illegal in the car? I said, do you have anything illegal on you?
So cold. Can we get a canine sniff, please?
Yeah.
What's that? You want them closed?
Oh, close them. I thought you said open them.
All right, here comes the drug dog. Notice that the dog is not at all interested in DJ's car. In fact, he's running towards the police car. But after the dog shows little interest, you see how the scam operates. The handler whistles at him and basically pulls him to the passenger side door where they know DJ's backpack is sitting on the seat. They've just had the doors open, so the smell's wafting around. Finally, the handler just has to tap on the car and signal to the dog that he's supposed to do something. Then the dog signals, which presumably is sitting. And then he's given a treat for doing so. Clearly, the dog was responding to that and didn't smell anything in DJ's car because there wasn't really anything in there. Though that didn't stop the cops. The supervisor, the lieutenant, sees what's happening, that the dog is not interested. He knows what comes next, and so he turns away so his body cam does not capture what happens. The rookie, only on the job 3 months, just stares right at it, and we get to see what actually happened. And of course, that didn't make it into the report either. Then the lieutenant, who perhaps wisely wasn't looking when the dog quote-unquote alerted, went over to DJ and says, yeah, well, you probably saw that the dog alerted. What are we going to find in your car? DJ's confident that they're not going to find any narcotics in his car. And DJ calls them out on the fake dog alert.
I'm sure you just saw the dog. So the dog gave a positive alert for
I
presence
saw
of
him
drugs in the car.
tap up there, but there's nothing illegal. I've never done drugs in my life.
There's nothing illegal. Okay.
No.
All right. Now it'd be time to tell us if there was.
No, there's definitely not.
Okay.
Now, with their supposed probable cause, they completely toss DJ's car. The lieutenant himself searches through all of the contents of DJ's backpack, which he's been carrying around for a long period of time. It just has all sorts of stuff in it. It has all his medications. It has past medications. It has over-the-counter stuff in it. And the goal is to not even just find something illegal, just something that they can say looked illegal, so that they can arrest and prosecute DJ as some sort of drug dealer. It doesn't matter if you end up beating the charges. It's about putting you through the process. That is the punishment.
Been seeing one of these little shit boxes for a while. I got your bag, sir.
So the lieutenant is searching through this bag. The officer standing in front of him is the canine handler. And now there's a discussion regarding the canine alert scam. This sounds an awful lot like me to an admission that it was a scam. There was no alert. That's why they're laughing about it.
I said, K9 in the car. He's like, yeah, I saw him tap up there. Like, bitch, shut up. That's what he said.
You'd better
do
something.
Ay, nena.
So where's the powder? Appreciate that.
You are testing all these, or are you selling them out?
I think he's had enough.
Bye-bye.
Business is it of yours, friend?
And that's what they did during the arrest processing, is they had the drug task force come and do field testing on whatever suspicious substances they found in this backpack full of stuff. Nothing positive for being narcotics or anything illegal. They still ended up sending some of it away to the West Virginia State Police State Drug Lab. None of it, of what they sent, tested positive for anything illegal. They said they found some marijuana tar. They never bothered to test that. To make a long story short, there was no proof that there was anything illegal in that car, yet they arrested him, took him to jail, all that, and charged him with basically being a drug dealer. Not only that, but intent to deliver. I mean, they threw everything at him that they could. He had nothing illegal. When the results came back, the prosecutors dropped all of the drug charges, and ultimately the obstruction charge was dropped as well because it was completely bogus, as evidenced by the video footage. So remember, just because you did nothing illegal, it does not mean that the cops cannot arrest you and cannot treat you like a criminal and cannot drag you through the criminal justice system where months, maybe years later, your case gets dropped and drug tests finally come back. Well, it looked like drugs. However, we didn't know. We're not scientists. And it's just unfortunate that DJ had to go through this. When all he did was not have a valid inspection sticker on this crappy little farm car that he was using to go get feed for his animals. His only real crime was questioning the authority of this police officer who's been on the job for like 3 months, and he was working at Chick-fil-A before this, like, and now he doesn't even work for the San Diego Police Department. He's been hired by the West Virginia State Police. So go watch both of my last videos, both of which have to do with the West Virginia State Police, and I think you'll see how you get these problems. You get these sorts of people who are tyrants from a young age. So we filed a lawsuit, made it through most of the discovery stage, we've taken depositions. Next, there will be dispositive motions to the court. If you want to follow along, subscribe, go here and at the blog at civilrightslawyer.com. Follow me on Twitter at JohnBryanESQ. I'd like to hear your thoughts in the comments about the drug law. Did that look like an alert to you? Remember, our rights don't end where fear begins. Freedom is scary. Deal with it.
Freedom's not scary. Freedom's awesome.
Take the freaking cuff off so I can get my loss, you corrupt pig.
This police officer claims to stop to check on this guy just to help him make sure that he was all right.
Oh, I was driving by, I saw the window, and I want to make sure everything was all right.
The guy was fine, and he did not want any interaction at all with the police. And gee, he really did help him, peppering him with questions, harassing him, threatening him with violence.
You have your ID handy, sir? What's your first name? Somebody help me! I don't have police. Is this a public roadway? So I don't have to move. Harassing is a repeated behavior, sir. That's very disrespectful and rude. One way or another, I'm going to come out of this car.
Oh my god.
You need to stop that.
Oh my god, now that's bad. Tyrant from a young age. Something happened to them. Their dad abused them or something. They didn't get what they want at some point in their childhood.
This is who the hit's for. It's so close.
So why was it that, despite this cop's best efforts, he was forced to let this guy go in humiliating fashion?
Take him out of hand. Lawsuit. You corrupt pig. Lawsuit. Lawsuit. Give me all of their names right now.
Let's break it down.
They won't ask any
Everything
questions.
requires a
Best keep out of
subscription.
sight.
And the worst part about it is that if you're like me, you completely forget how many subscriptions you have or how much they are costing you every month. And for subscriptions that you don't even use anymore. How great would it be if there was an app that kept track of that for you and then helped you to cancel those subscriptions that you don't even use anymore and also help you track your bills? That's why I love this video's sponsor, Rocket Money. Rocket Money is an all-in-one finance app that helps you save more and spend less. It allows you to manage subscriptions, lower bills, build a custom budget, and grow your savings all in one place. But my absolute favorite part of using Rocket Money is canceling unwanted subscriptions. It securely identifies any recurring charges that you have and allows you to cancel those with just a few taps. You never even have to get on the phone. They do it all for you, and they've helped customers save over $500 million in canceled subscriptions. Rocket Money can help negotiate your bills for you. No customer service calls. Let the app's negotiators do it for you. So if you want to save more and spend less, go now and join the over 5 million members currently using Rocket Money. Here's what you do. Go to rocketmoney.com/civil or click the link in the description to get started for free. Get your money right by using Rocket Money. Thanks to Rocket Money for sponsoring this video. Now let's get back to it.
Not my usual type. Too many muscles. But if you've got a drachmi, we can come
This video
to
comes
an
to us from
arrangement.
Margate, Florida.
This
It involves a
said I'd
guy
find you
just
here.
sitting inside his car that is parked
my
in a
darling
public
Thespies,
park.
an
Officer
artist in
Sohn
so
of the
many
Margate
ways.
Police Department
But let's
sees
talk
this
about
car
us.
sitting there. He has not observed any crime being committed. Nobody has told him that any crime has been committed. Nevertheless, he sees something that causes him to want to get out of his police car and approach this guy. The issue here is, what are the rights? What is the law when police officers confront somebody such as this?
God damn it.
Have to talk to him? Is he free to leave? Can the police officer force him out of the car?
There's some worms in my head that I need out.
Can they harass him? Can they annoy him? All of these cases are highly fact dependent. The first thing we need to look at is, what is the reason for this encounter? As far as I can tell, this police officer just observed this car, noticed that